What assets can be placed in an irrevocable trust? Have you ever wondered what types of assets can be placed in an irrevocable trust? This question is especially important for those considering Medicaid planning and elder law. An irrevocable trust is a legal arrangement where the grantor permanently transfers ownership of assets to the trust. Once this transfer is made, the grantor relinquishes control and rights over those assets. This structure is often used to protect assets from being counted toward Medicaid eligibility and to preserve wealth for beneficiaries. Let's talk about the types of assets that can be placed in an irrevocable trust. First, real estate is a common choice. This includes primary residences, vacation homes, rental properties, and even undeveloped land. Transferring real estate into an irrevocable trust can protect it from creditors and Medicaid estate recovery. However, if there is a mortgage on the property, you may need lender approval, and it is wise to review any tax consequences. Next, cash and financial accounts can also be transferred into an irrevocable trust. This includes savings accounts and certificates of deposit. By doing this, these liquid assets are removed from the grantor's estate for Medicaid eligibility purposes. However, keep in mind that large amounts of cash may be better managed through other financial planning tools, since flexibility is lost once placed in the trust. Investment accounts are another option. Stocks, bonds, and mutual funds can be held in an irrevocable trust. This helps shield these assets from being counted as personal assets for Medicaid qualification and protects them from creditors. If you own a business, you can transfer ownership interests in closely held businesses, partnerships, or limited liability companies into an irrevocable trust. This can protect the business assets and help with succession planning. Life insurance policies are also eligible for transfer. By placing the ownership of life insurance policies into an irrevocable trust, the death benefit proceeds can be removed from the taxable estate and protected from creditors. Lastly, valuable personal property such as jewelry, artwork, collectibles, or vehicles can be included in an irrevocable trust. However, some personal property like vehicles may be exempt from Medicaid asset calculations and might not need to be included. It is important to note that certain assets are typically not placed in irrevocable trusts. Retirement accounts such as individual retirement accounts and 401(k) accounts usually have specific tax rules and are governed by beneficiary designations, so they are generally not transferred into irrevocable trusts. Medical savings accounts and health savings accounts are designed for medical expenses and often retain protections without needing trust placement. Additionally, some vehicles may not require placement in a trust because they are exempt from Medicaid asset limits. When considering Medicaid planning, placing assets into an irrevocable trust is a strategic step. Assets transferred into such a trust are typically not counted as personal assets when determining Medicaid eligibility. However, there is a 5-year look-back period for Medicaid. This means that transfers made into the trust within 5 years before applying for Medicaid may result in penalties and delayed eligibility. Once assets are transferred into an irrevocable trust, the grantor cannot alter the terms or reclaim the assets. Therefore, it is essential to seek careful legal guidance when setting up the trust to ensure it meets your goals and complies with Medicaid rules. In summary, common assets placed in irrevocable trusts include real estate, cash, investments, business interests, life insurance policies, and valuable personal property. Understanding these options can help you make informed decisions in your Medicaid planning journey.